Remember all those COVID vaccine mandates that employers were requiring their employees to take? And if they didn't, they would be fired, even the remote workers. And then when the employees asked for a religious accommodation, a lot of employers said, talk to the hand. Well, I have 12 million reasons why that probably wasn't a good approach on the part of the employer. I'm Karen Michael, and you're listening to The Job Judge. Welcome to The Job Judge, the podcast for anyone who works. I'm Karen Michael, your host of The Job Judge, where together we navigate through all these legal landmines and workplace dysfunction that's probably happening in your organization. And I try to give some advice to employers and HR professionals so they don't make these big mistakes that these other companies are making. Of course, a couple ground rules. I am an employment lawyer, but I cannot give legal advice here on the podcast. And you don't want to miss an episode of The Job Judge, so be sure to follow, subscribe, like, comment, so that you don't miss an episode of The Job Judge. So let's go back to 2021, 2022, when these employers were requiring employees to take the COVID-19 vaccine. And I'm not just talking about any employer. I'm including employers where employees worked remotely. You need to take that vaccine because it's for the public good, and therefore, if you don't, you're fired. And there were a lot of employees that asked for a religious accommodation, saying, I don't agree with taking the vaccine. It violates my religion. And a whole lot of employers started to second guess the sincerity of the employees' request for an accommodation. So let me tell you about Blue Cross Blue Shield of Michigan and what happened in that case. So the woman's name is Lisa Domsky, and she was required to take the COVID-19 vaccine, and she sought a religious accommodation. So according to the lawsuit that was filed, she alleged that she submitted a religious accommodation request for exemption from the defendant, Blue Cross Blue Shield of Michigan, COVID-19 vaccine mandate. And she claimed she was terminated for not having, quote, sincerely held religious beliefs. And she was terminated on January 5th, 2022. And the lawsuit notes that despite the Equal Employment Opportunity Commission, at the time, they published a bunch of guidelines and guidance. At the time, the Equal Employment Opportunity Commission told employers to, quote, ordinarily assume that an employee's religious request for religious accommodation is based on sincerely held religious belief, practice, or observant. According to the lawsuit, defendant did the opposite. Instead of respecting Ms. Domsky's religious beliefs, according to the lawsuit, the defendant conducted a short, arbitrary interview with her regarding whether she had taken other vaccines or over-the-counter medications. They then, according to the lawsuit, ignored the EEOC's warning that employers, quote, should not assume that an employee is insincere simply because some of the employee's practices deviate from the commonly followed tenets of the employee's religion, or because the employee adheres to some common practices but not others, and the defendant terminated her, they said, based on subjective standard of religiosity. All the while, the defendant did not require the customers, vendors, or independent contractors on its premises to be vaccinated. So here's what she alleged. She said that she was employed by Blue Cross Blue Shield from March 10th, 2008 until her termination on January 5th, 2022. Her most recent job was IT Process Specialist 2. She was employed by the defendant for 19 years. The defendant announced a mandatory COVID-19 vaccine policy for all employees and contractors, including those working remotely, on or about November 1st of 2021. The defendant required employees and contractors to be vaccinated by December 8th, 2021. So it gave roughly 5 weeks to get vaccinated. The defendant didn't require visitors or vendors to be vaccinated, and the last day for employees to request accommodations to the vaccine mandate was November 11, 2021. The decision whether to grant or deny religious and medical vaccine accommodations to applicants was made less than 2 weeks later. The employees denied accommodation were automatically placed on unpaid leave of absence from December 9th, 2021 to January 5th, 2022. They claimed that the accommodations process was arbitrary and woefully inconsistent. They conducted a series of, according to the lawsuit, ambush-style interrogations with employees who submitted religious and medical accommodation requests. The defendant's employees were not informed of questions ahead of time. Attorneys for defendant questioned employees, but employees were not allowed to be represented by legal counsel during questioning. The interviewees were told that the interview had a maximum time of 15 minutes in duration. So you got 15 minutes to answer these questions. And if you don't answer them the way we think they should be answered, you get the shot or you get fired. Doesn't matter that you're working remotely and you're not going to have access to other employees. No, we don't care about any of that. All we care about is that you get the shot. That's all we care about. When employees were asked, they were warned to just answer the questions or else they would be denied accommodations. The interviewees were threatened to keep their answers short and to the point because time was running out, quote unquote, and time was, quote, limited. Blue Cross Blue Shield told interviewees it had not received their written accommodations requests. Defendants denied accommodation to interviewees with language barriers or difficulty answering questions due to medical conditions. Now, according to the lawsuit, these are the questions that were asked during this interactive process that the defendant employed in their 15 minutes that they gave for employees to plead their case to say that they objected to taking the COVID-19 vaccine because of religious reasons. The defendant asked the employees the following questions. 1, do you feel like the COVID-19 vaccines were rushed? Explain to me how that determines your religious accommodation need. What do you do when you are in physical pain? Do you take aspirin, Sudafed, Tums, or Tylenol? Do your beliefs prevent you from receiving medical treatment? Do you have a primary care physician? Has your doctor ever prescribed medication? What would you do if your doctor prescribed medication? What medication have you taken? Have you always followed their religious belief? And when was the last time you received a vaccination? Employees were told that over-the-counter medications like Tylenol and Tums were developed and manufactured using stem cells, which I believe that has since been debunked, but that's not the issue right now. However, according to the lawsuit, the over-counter medications referenced by defendant were developed decades before stem cell research was conducted. Moreover, many of defendant's employees were objecting to the COVID-19 for religious reasons that had nothing to do with the stem cell research. According to the lawsuit, the defendant terminated approximately 250 employees who requested a religious accommodation to the COVID-19 vaccine on January 5th, 2022. The defendant incentivized employees to retire early in 2020 in order to reduce staffing costs, but defendant did not have to eliminate jobs in 2021 because it terminated so many unvaccinated employees. The defendant touted on job recruiting websites that it required COVID-19 vaccination with, quote, no exemptions. The employees denied the accommodation to the vaccine mandate. The employees that were denied the accommodation to the vaccine mandate were forced into what it says a horrible position of choosing between a vaccine or termination. And they cited an interesting case from the Fifth Circuit Court of Appeals, which said, it was a United Airlines case, which said, forcing individuals to choose between their faith and their livelihood imposes an obvious and substantial burden on religion. Vaccine mandates presents a crisis of conscience for many people of faith. It forces them to choose between two most profound obligations they will ever assume, holding true to their religious commitments and feeding and housing their children. To many, this is a most horrifying of Hobson's choices. Defendant terminated remote employees who remained unvaccinated despite those employees posing no discernible risk to their coworkers. Now, specifically to this employee, she stated that she makes all decisions, especially those regarding vaccination and other medical decisions, through prayer. She submitted a religious exemption request for the COVID-19 vaccine. She was interviewed by the defendant before her accommodation request was ultimately denied. The plaintiff, maintaining her sincerely held religious beliefs, did not receive the vaccine and was subsequently placed on unpaid leave. So if she did not have a sincerely held religious belief, she sure took a bad situation by being fired because she felt so strongly against it that she got fired for it. Plaintiff was ultimately terminated. The religious accommodation process mandates bilateral cooperation between the employer and the employee. No such bilateral cooperation occurred during the defendant's interrogation of its employees or otherwise during the process. Now, what's interesting is all of this is governed by Title VII of the Civil Rights Act. And according to Title VII of the Civil Rights Act, an employee has a right to not be discriminated against or harassed based on their religion. And they also have a right to a reasonable accommodation for their sincerely held religious beliefs, unless providing that accommodation would pose what's called an undue hardship. That concept of undue hardship has recently actually been updated by the Supreme Court to include a higher burden for the employer to meet in order to prove that it would be an undue burden. And the problem that I think a lot of people have with the request for accommodation is that people wrongly believe that there are only a few religions, and that if you don't subscribe to all of the tenets of that faith, then somehow you aren't religious. And for example, this employee is Catholic. And you might recall that the Pope came out and said vaccines are fine, you can take the vaccine, there's no issue to the vaccine. And so wrongly, employers threw up their hands and said, well, anybody Catholic should be able to take the vaccine because the Pope says it's okay. It's not up to the Pope to decide your religious beliefs. It's up to you to decide your religious beliefs. It's extremely individualized. And what the EEOC says in their guidance is that Title VII defines religion very broadly. It includes traditional organized religions such as Christianity, Judaism, Islam, Hinduism, and Buddhism, but it also includes religious beliefs that are new, uncommon, not part of a formal church or sect, or even only held by a small number of people. And when I posted about this case on my LinkedIn, I was a bit surprised at how many people were just appalled that a person would even make a claim for a religious accommodation, and how fake these people are who are making a request for a religious accommodation, not understanding that the law is very broad. It's not just saying, well, all people who practice Judaism believe in X, and their Judaism believe in X, and therefore you don't believe all of it. That's just not how it works. And this is what the EEOC, the Equal Employment Opportunity Commission, who regulates these types of, enforces employment discrimination, this is what they said. Some practices are religious for one person, but not religious for another person, such as not working on a Saturday or on Sunday. One person may not work on Saturday for religious reasons. Another person may not work on Saturday for family reasons. Under Title VII, a practice is religious if the employee's reason for the practice is religious. So if the reason I'm not eating meat is because of a religious belief, that's protected by law. If the reason I'm not eating meat is for ethical reasons, not religious reasons, then it's not protected by the law. So the law is very nuanced, which is why an employer should use caution from having 6 questions that they ask employees in a 15-minute interview to make a big decision on whether or not it is going to accommodate an employee's religious beliefs. It's a closed-minded approach instead of what is expected, which is a very open-minded, interactive process to figure out and make sure that we are getting to the right result. It is true that social, political, or economic philosophies or personal preferences are not religious under Title VII. So it's very important to determine whether or not the person is seeking the accommodation due to religious reasons. And even during the pandemic, the EEOC recognized that some employees would come out, would request religious accommodations. And in doing so, those same employees would be likely questioned about their religious belief. And if the employer was going to grant the accommodation, The EEOC themselves recommended as an accommodation that the employee be given the opportunity to telework. So it really makes it hard to understand how a person who's working remotely posed any threat to the workplace whatsoever. It should have been easy to grant this accommodation. And if you you read the things I wrote back then, I said the same thing then. Employers, be careful. You might want to be able to go out and brag like they did. Oh, we require everybody to be vaccinated. We're so socially conscious and all those things. And that was the response in my LinkedIn is, oh, these anti-vaxxers, how awful they are and all of these things. People have multiple rights in our workplace. Religion is one of them. It's not a fake. It's a reality. There are multiple rights that employees have in our workplace. The president of this Blue Cross Blue Shield announced in December, I want to thank all employees who are or in the process of becoming fully vaccinated and encourage any employee who is not vaccinated to consider doing so. That's fine. You can encourage employees. The question is, should you have forced employees, including those who had religious beliefs? He told employees in the weeks prior to the vaccine deadline that he anticipated denying accommodation requests and terminating many employees. By the way, that didn't fare well in front of the jury. They claimed that she was an excellent performer of her job duties. And they reminded in this lawsuit that Title VII defines religion to include all aspects of religious observance and practice, as well as belief. And the employer, again, should ordinarily assume that somebody's religious belief is sincerely held. An individual's testimony about his or her belief must be given great weight. So if I say it is, there really isn't a whole lot of documentation that should be required. Now, if there's a reason to be suspicious, I mean, I had a case one time of a woman who wanted to take off for Easter from work and then later was taking off for a Muslim holiday. And that raised the question of, are you just trying to get out of work or do you really have a sincerely held religious belief? The prohibition against religious discrimination imposes a duty on employers to accommodate the sincerely held religious observances of employees absent this undue hardship. And it doesn't satisfy this burden merely by showing that an accommodation would be bothersome to administer. They have to show it is an undue hardship. And so she claimed that she was denied this religious accommodation and she sued. And frankly, she won kind of big time to the tune of $12 million. And one of my favorite things to do is to read jury verdict forms because I just think it's interesting to watch a jury write things and handwrite onto these forms, these big numbers. And so on the verdict form, which I have here, they asked the jury the following. On the claim by the plaintiff against defendant for unlawful discrimination under federal law by denying her request for an accommodation consisting of an exemption to the defendant's policy that all employees be vaccinated against COVID-19 based on a sincerely held religious belief, we, the jury, find in favor of plaintiff Lisa Domsky. On the claim by the plaintiff against the defendant for unlawful discrimination under Michigan and federal law by terminating her employment because of her religion, we find in favor of the plaintiff. So they didn't only say that they denied her an accommodation, they said she was fired because of her religion. And this is what they chose to give her: $315,000 in back pay, $1.375 million in front pay, $1 million in non-economic damages, and $10 million in punitive damages. Now, that's going to get reduced because under federal law, there is a cap. And so we know that that's going to get reduced somewhat. That's not the point. Employers who have a desire to do something need to balance that against the rights of our employees to an accommodation. And whether it's a religious accommodation, whether it's a accommodation based on disability, and now with the Pregnant Workers Fairness Act, there could be an accommodation based on pregnancy, childbirth, or related medical conditions. All of those individuals who seek an accommodation from whatever the work rule might be, the employer is required to engage in a good faith interactive dialogue. And the goal is not to say, talk to the hand. We don't want to, the goal isn't to not find the accommodation. The goal is to work together to try and find a reasonable outcome and solution so that the employee can be accommodated. Now, that's not always the case. Generally, we don't have to remove essential job functions from a job. Generally, that employee is not entitled to any accommodation they request. But the hope is that you engage in this interactive dialogue. And according to her lawyer, who I did have the chance to speak with, he's got over 150 of these cases pending across the country. So back then, and I hope into the future, employers get their ducks in a row and understand that when an employee presents with a religious accommodation, if you can make that accommodation, you should, unless it presents an true undue hardship for the employer. And now it's time for Ask the Job Judge, where every episode I answer a question that I see online or somebody asks me on social media or emails me, and I can answer it here on the podcast. So this one is from Reddit. I love this one because there's a lot of discussion right now about performance improvement plans. PIPs. Are they just a road to termination? Are they fake? What really is a PIP? And this person writes on Reddit, "A miracle, I beat my PIP." This person says, "I was placed on a 60-day PIP in February. I had some personal challenges that definitely affected my work performance." Well, first of all, start with that. Kudos to this person for acknowledging this person's work performance issues. So many times I see employees who just will not accept that there are performance issues. And that's very frustrating because if you don't accept that there are performance issues, I promise you're not going to improve those performance issues. I was definitely being careless and not proactive, on top of a lot of office drama that I kept getting pulled unfairly into. My boss placed me on a PIP, and I buckled down for the next 60 days and really focused on work. 60 days came and nothing, not a word about my PIP at all, but I knew my work had drastically improved. I even requested a meeting about it, but my boss got sick the day of the meeting and never rescheduled it. Nothing was ever said about it. Fast forward last week, I had my performance review and my boss said that my improvement was astounding and that he looks forward to working with me in the next year. And I got a great review. He even said that my company wanted to invest in me taking advanced tech courses in 2025. I'm taking that as a pretty good sign that I've beaten my PIP, but I'm not going to slack and think I can mess up again. I love this case and I love this situation because almost everything was right here. First of all, I think it's great if an employee is put on some sort of improvement plan if the employee needs to improve. That's the whole purpose of performance management. So if the employee needs to improve and there's a room for improvement, unless the employee has screwed something up or there's no hope of the employee getting better, maybe they don't have the right skill set, it's obvious, or they just are done something horrible. Generally speaking, the PIP, I think, is fine. I don't know why people are so opposed to this concept of a performance improvement plan. But in this case, this employee took accountability. That's the key. That's what's missing in our society is this concept of accountability. This employee said, I slacked, I wasn't doing a good job, but I buckled down, I valued my job, and I survived my PIP. And here he is now, he overcame it. And kudos to the manager and the company for being able to recognize that this person had overcome the performance issues and now seeing the value of this employee into the future. I'm not thrilled that that manager didn't meet with this employee at the end of the 60 days to say, great job, you've overcome the PIP, because now this employee had to suffer a lot of stress, not knowing the person's status. So I don't love that. I wish that the manager had met with the person at the end of the 60 days and said, check, 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 you're done, you're good, it's to the side. But regardless, the person did get a good performance review, and hopefully this person will have a long career. I hope they continue to post on here about their career. Thank you so much for listening to The Job Judge. Be sure to follow along. Hit the subscribe button. Don't miss an episode of The Job Judge. I'm Karen Michael, and you've been listening to The Job Judge.